Just judges.
Let Madhavra, this para 141 at page 767 of this compilation.
Seventy. This is good. Weird. Huh? Weird. This one communication. 22 they are followed. Into 33. Mr. Attorney,
Yes.
we are just looking at Goodyear India Limited versus State of Haryana. Justice Sabyasachi Mukherjee says, no, you have shown decisions that if a point does not arise and something is said, there is not a precedent. He says, if a point arises in a case, a decision on a question which has not been argued cannot be treated as a decision.
That's right.
If the points may have a reason, but was not argued. So even then,
That's it's higher level. Further level.
higher level. The point arises, but not argued.
That's where I think the sub-silencer issues come in. It ultimately means something which is not perceived by the court as necessary and will look into and consider. It would have been probably very intellectually inviting for anyone of this to say, please refer to a larger bench, a very important question to be considered. And I think we are in on two issues, and the issues of teachers who would like to continue in their position, and the fundamental question which I raised about the right to education, which somehow seem to have been overlooked in both in the three-judge judgment and the Pramati opinion. I thought that for having regard to the importance, that principle which needs to be emphasized as much saying that's made reserve. I don't think I was very keen to say tell the court, please refer to a larger bench. This can be done, but the bench says so and so is not binding, there's no precedent value, and the court can probably deal with the matters directly present before. Namely, what do we do with the question of right to education as again balancing the concerns of teachers who would probably have not been able to pass.
Do you place 21A at a higher pedestal than 30?
Yes.
Than 30? Or it has to be balanced?
They have to be
It
balanced.
has to be
I
balanced.
don't say, but then, as I said
Because
earlier,
whichever decisions have come on the right of the minorities, that was at a point of time when 21A was not there. Really. First decision is perhaps the treatment of Justice Kapadia, and then in this Pramati, the Rajasthan case and from. But 30 to 30 was one.
may I put it like, I understand your first point. I don't think there's an area of conflict between 21A and 30. If somebody suggests there is an area of conflict, probably that's a misconceived suggestion. Because 30, as I said earlier, would serve 21A. So you can't say therefore 30 operates in an area where you find those overlapping areas of conflict, and therefore 30 will be higher, 21 will be lower, and vice versa. So I don't think that way of construing 21A as antagonistic 30 and vice versa, I think would not be an appropriate way of looking at it. Yes.
Please turn to page 795.
795.
Volume 2.
Volume.
Pramati, para 55.
Yes. Sir. Yes. When we look at the 2009
Yes, you can come down to just between
That's it,
Lacetum
yeah.
E and Epsilon,
that's it.
even a little prior that while discussing the validity of Article 15.5.
We have held also,
While
in
discussing,
our view,
while discussing the validity.
while discussing correct.
Yes.
The validity of clause 5 Article 15, we have held that members of the community other than minority community, which is established in the school, cannot be forced upon minority institution because that will destroy the minority character of the school, in our view. If the 2009 Act is made applicable to minority school, aided and unaided, the right of so-and-so will be abrogated. Therefore, Act insofar as made applicable to minority school, referred to so-and-so, Article 13 is ultra-virus, the Constitution. So it means only that provision which may have this implication, not the entire Act.
No, but here they're talking about the old Act. No, in our view, the 2009 Act.
And
the
the
problem is,
it only means in the context of the infringement of any of the minority rights under 30, any provision of 2009 Act, if it has such an infringement effect, then we say it is. Otherwise, an unexamined part of the whole law can't be declared unconstitutional.
see, the society's judgment of 3 judges examines various provisions of this Act. It's not confined to 12 months.
In this.
No, society. The
That's
first one, 3 judges.
But you will also notice in that case, and they examine various provisions, very often when the court finds a particular provision violating of a particular provision of the Constitution, the court examines in that context. But even in the society case, I did not find that the examination of each and every provision of the Act with reference to 14 or 21, therefore it violates 14, 19, 20.
No, you're right. But only question over here is that these observations are not stray observations, right? They have pitched it in the context of validity of Article 15.5. When they are examining the validity of Article 15.5, they have pitched it at that and linked it with that.
Correct. I have only one small reservation here.
No, our concern is only this.
I tried to explain a lot. And the problem is,
Here the teeth of it. See, it's a categorical observation. It's a categorical finding.
Yes.
It's not something they have missed. You can't say they have missed out something. We can clarify this. We can't clarify. It's cogent. It's direct.
They have missed one thing.
I would probably say that.
They have missed a lot of things.
What
But about
essentially
members of your own community?
So they are not.
To that extent, it could have been dealt with.
Right. The only question is.
we may read the entire paragraph again. But what fell for adjudication in this case was a complaint from unaided non-minority institution under Article 19(1)(g). We are being discriminated. So you're being told to take students under Section 12(1)(c). So minorities do not have that obligation. We have that burden. Therefore, discriminating. It's in that context.
No.
15(5).
Context is 769. The two questions which are framed.
Correct. 15(5) and 21(a).
In the context of basic structure of the constitution.
That's true. But then who were before the court? Unaided non-minority institution. Therefore, they had a question of discrimination. Essentially discrimination. But then let's also look at a broader perspective. Both minorities and non-minorities, what are they talking about? We have a right to run educational institutions. So it's in that context, who should bear which burden? And who need not bear what burden? Therefore, under that question, that question has been answered. No difficulty at all. They need not bear the burden. But to go beyond that and therefore say something, the entire act is. I thought that's why you right.
Let us assume that, let us agree with your submission that they have gone beyond.
Yes.
But if they have gone beyond, that can only be done by 5.
No, perhaps you not
We can't.
That's why I place all the judgment to show where something was not even an issue for consideration and not even,
Sub salientio means not argued, not commented upon.
I'm not.
By logical deduction, you can't say that the point has been decided.
Here
it is not by logical deduction. It is categorical finding in this case.
I place it only for the purpose of understanding where.
From 12(1).
There's a very subtle move
That
from.
should not. And then if you read,
Declared 15(5) is constitutional, 21(a) is constitutional. Having said that, in this case,
Yes. No, what I was putting to you was that sub salientio basically means a point not urged, not decided. You cannot say because the suit for civic performance has been decreased, then all the pleas which could have been raised, which should have been raised, are decided. That is what sub salientio is. Not that the finding which has been given by the court, categorical finding by the court, will be treated as sub salientio.
I would probably urge the court to consider because it becomes a ratio. It's a ratio.
Then it is obiter. Then according to you, it is obiter. Then you will not be on sub salientio. Sub salientio will be slightly nuanced.
Why laboring little hard on that?
Yes, no,
I understand it. But obiter for the court, you can say it is an easy way of explaining it. But I thought there's a subtle issue which is for consideration here. So, after all, these doctrines evolve as common law doctrines and to assist the court in this adjudicatory process. And if I look at paragraph 55 again and again, I find that it's just a leap. It's just a leap.
It is a leap.
It's a leap.
Let's take it as a leap.
Right.
Let's take it as a leap. Then also, I think we'll have to send it to a larger bit. We
No,
can't
right.
explain the leap.
Your lordship can say it's a leap.
Yes, and then
That's
according to us.
If that price is a leave,
Yeah.
I don't think then nothing more required to be done by any further court. That's what I tried to say. If the court says there is a leave, then the court is now relieved from saying we do not find ratio let a matter be referred. The question of referring to a larger bench may occur in different circumstances I explained earlier. So when there is a real difficulty which has to be explained away by a larger bench, we have all those cases where multiple judgments take one view and suddenly another bench takes a contrary view, and therefore the need for appeal to a larger bench to settle the law. And I understand, in fact, Article 145 itself says if there is a constitutional interpretation, the matter will have to go to a bench of 5 judges. But it doesn't happen like that. Very often goes, as we call 2 judges, 3 judges, they send it to a constitution because 145 says so. But not every case like this becomes a 145 situation. So therefore, I would probably urge the court that having regard to the importance of deciding it within the framework of the factual matrix which is arisen in this case. Otherwise, I would have happily said yes, please refer to a larger bench. But I think on facts, I don't think the need to go to a larger bench. We have to decide and more importantly, by understanding the NCTA Act and the importance of standards of education. Standards of education is now the province of this particular legislation, the authority, which has been recognized under the Right to Information Education Act. So there is no disagreement on that question. That can't be. So what I mean to say is what they said in paragraph 55 when they say therefore the 2009 Act. I will probably only ask because the court will say 2009 Act, particularly this provision insofar as made applicable also. That's the only clarification. That the judgment will not be read beyond this limited consideration. I was referring to that last few lines again. Therefore, the 2009 Act, insofar as that means the provisions of Section 12(1)(c), that's what fell for consideration just preceding this observation. The provisions of Section 12(1)(c) of the 2009 Act, insofar as made applicable to minority schools, will be violating schools. I think that's why we in English I use the word the Freudian slip, though it's in different contexts. It's eventually a slip. So whether a long journey of reference to a larger bench and other attached uncertainties, etc.
Mr. Chakul here.
Yes.
Having regard to Section 3,
Yes.
the definition of child
Yes.
today. No, Article 21A is conceived in the interest of children between 6 and 14.
Yes.
So apart from this identified class,
Yes.
none else can enforce this right, except of course if a parent or a guardian
Yes.
seeks to enforce it on behalf of the child.
Yes.
Now let us assume that there is a minority school in the neighborhood where this child resides and it is the only school. Now the child wants to take admission in that school. Not under 12(1)(c).
Yes.
12(1)(c). He wants to take admission in that school. Now can a minority school deny him admission on the ground that he speaks a different language or that he professes a different faith?
He belongs to the minority.
No, he does not belong.
Does not belong.
Either the linguistic minority or the religious minority. But this is the only school in the neighborhood. Can he be denied admission if he is between 6 and 4?
By virtue of this judgment, he can be denied.
No, forget about judgment.
Yes.
We are asking you as an officer of court.
Yes.
Under the law,
Yes.
what does the law say?
I'll tell you, Lordship. Yes.
Something on the.
Yes, I'll tell you, Lordship.
Now, it is not government forcing him.
Yes.
He simply goes and says that I want admission in your school. This is the only school in the neighborhood. I want to be an educated man. Please admit me in this school.
I'll tell you,
You
Lordship.
say,
Yes.
sorry, you do not belong to my linguistic community or religious community. I will not admit you.
Yes.
He goes and files a petition under 226
I'll tell you, Lordship, Lord.
and says that I am enforcing my fundamental right under 21 capital A.
I understood your Lordship's question, Lord. I'll answer it. The Lordship may see Article 29, Lord, and 29.
Constitution.
institution is an aided minority, then, my lord, they are under a constitutional obligation to part with certain number of seats to members of other communities. That is a constitutional obligation under 29. So, therefore, my lord, if a particular ratio is provided,
Let us take it that this is an unaided minority institution.
if it is unaided, my lord,
You have a right.
yes,
Your
Right,
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 will,
he can
your right will prevail over 21 capital A.
no, my lord, if it, I'll tell you, lord.
Your right is to establish an educational institution.
Yes,
And this is directly related to 21 capital A.
now, my lord,
In
21
such
days.
a case, whether it will be the child's right which has to be protected.
Now, my lord,
A
21
child
days.
coming to your school, can you refuse him admission?
May I put it, my lord, yeah, I tell you, lordship.
Then we would be taking
Now,
our country back
now, my lord, I'll tell you, lordship.
from what is thought to be achieved by 21 capital A.
My lord, 21 capital A says the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. So, my lord, your lordships considered in Pramati as to whether the law contemplated under 21A can be extended to minorities. And your lordships, after considering all the previous authorities, have come to the conclusion, since it will make an inroad into the right under Article 30, since it will change the minority character, the law contemplated under 21A cannot apply to minorities. It is in that context, my lord, the Constitution bench has said, my lord, that this act cannot apply to minorities.
That would mean that irrespective of 21 capital A, I am free
Then, my lord,
to administer my institution.
now I'll
I
tell you.
did not care about 21
No,
capital A. I did not look at the larger public interest,
I will tell you.
larger national interest,
Now,
that children should be educated.
I will explain. My lord. Now, my lord, before 21 day, before 15.5, my lord, this question arose in Inamda. Now, my lord, because of matter which was referred to
It
Inamda.
was not considered. Have you found any reference in Pramati to section 3?
No, my lord, 3 is part of 12, my lord. 3 is actually, 3 and 12 are actually together, my lord. 3 cannot stand independent of 12.
3 is
To
an
give,
adjunct of 21 capital A,
correct,
the authority, the
Correct.
right of a child.
right, my lord.
And 12 is something
Yes,
through which
yes,
the state can impose something upon the minority institution for the child.
yes.
I am putting a question to you. Here, there is no intervention of the state. State is not imposing anything upon you. I am a child. I am claiming my right under 21 capital A. That is a
It has to be, now, my lord, 21 day.
institution because your institution is the only institution in my neighborhood.
I'll tell you, lordship.
Why do you force me
No,
to
I am,
travel from one village to another
no, my
for
lord,
the purpose that
yes.
would that not defeat the
No,
purpose of
21.
the act?
Would your lordship kindly see 21 days is as by law which is declared by the state. So 21 days
So, it-
based
21
on a law made by the state.
21A cannot capture
Yes,
all contingencies. It
Yes.
has to be provided by law.
yes,
So
Yes.
today,
correct.
most of India is rural.
Yes,
We don't have schools in villages.
yes,
You have found in social media now
yes.
that children have to cross rivers going to school.
Now, I'll tell your lordship, my lord.
Now, if there is
Yeah.
a school in your neighborhood run by a
I'll tell your lordship, my lord, if your
and
lordship,
you deprive the child
your
only,
lordship calls for a report, your lordship will come to know it is actually the minorities, it is the missionaries who have started schools in all these villages. And they are actually providing admission to all these category of students, my lord. Large number of schools where nobody would even try to go.
right?
Well, the minorities are established in different parts of the country, my lord, right from,
noble objective.
yes. And they are giving it.
Why would
I'll
you
tell your lordship, my lord,
not
why?
abide by 3?
Yeah.
Why would you not abide by 3?
No, my lord, I will tell you, even without that, my lord, they are actually doing it.
put it slightly,
Yes.
a little more nuanced.
Yes, please.
Suppose the obligation is only to admit children from the minorities who belong to the EWS section of the minorities. Would that be violative of 12(1)(c)? Because that would not,
It may not. It may not.
that may not disturb your
It may
minority
not.
character.
It may not. But in fact, Lord, it may not, Lord, because
So
Only-
how do you react? Because once you say that 12(1)(c) is totally outside the ambit of 21A, we are putting to you, suppose the state were to say that no, you admit only EWS section of the minority.
I'll tell you, Lord, Subramanian, that is taken care of under 30. They are actually giving it. There is
but-
No,
but
this is a
25%
declaration of law.
Now it's a
It is a
25%
declaration
quota.
of law.
It's a 25% quota. That you may be going even beyond the quota at times, but at times you may be less. When it is less, can the state say no, you must touch 25% in this academic year also?
And for this, the entire act is ultra vires.
No, my Lord,
How
that
could
Lord,
it be?
no, my Lord,
How could it be done?
I'll tell you, Lord, Lord,
It was considering only from a narrow perspective as to whether there is violation of 15(5), whether there is violation of 30. 21 capital A, whether is violative of these two.
but while considering
Now,
it,
while answering that, up to classical E, we can accept what the court said. But there is a radical change after classical E, only because 2009 Act is said and not with reference to 12(1) or
Millard, I tell you, Lord, what the learned attorney
Does it
was
follow?
concentrating was,
No.
Paragraph
Yes,
55.
Mr. Chacko,
Yes,
55 has two parts.
yes.
That's the first part. Can you read the second part?
The Lordship may also see 54, the last paragraph of 54. What is actually missed is actually the last part of 54, which says, my Lord, the law contemplated under 21A cannot violate Article 13. So therefore, my Lord, that is not actually considered. Your Lordship may see the paragraph, second paragraph.
Yes.
Thus, the power under 21A.
That's
Yes.
what we are asking you.
Yes, Millard.
Is that the correct observation? Suppose under Article 21A, they make a law,
Yes.
or Section 12(1)(c) is read down.
Yes.
To mean that you will admit EWS category of your own community. How do you answer that? It can be toned down. 12(1)(c) can be toned down, not from the general community, only from your community.
Millard, I'll tell you, Lordship. Millard.
Well, how would you react? Therefore, this observation is getting some
I-
ambiguity for us.
In fact, Millard, that question did not actually arise for consideration
Therefore,
because
yes.
No, it
there was
did
no
not-
complaint. There was no complaint that minorities are
Laid
denied.
down a law in broad
Yes.
terms that
Yes.
the entire act is not applicable.
Now, Millard,
This point was not from the bar, taken from the bar. While we were looking into it, both of us discussed, and we wanted you to react to this.
Yes, I'll tell you. Millard.
So therefore, it did not occur in the minds of any of the judges in the bench. Maybe even the lawyers did not visualize this point. Whenever an act is under challenge, apart from presumption of constitutionality attached to every legislation, the next step for every court is to save the law
Yes.
from being struck down. How does it do? Does it by a process of weeding down? This presented a classic case where the law could have been read down. Then it is confined only to your community. How does it violate? No answer in the judgment. We are putting it to you.
Let me put it two ways. Millard. One, my Lord, is 15.5. No, my Lord, 15.5 is happened. What does 15.5 say? That notwithstanding anything contained in any of the judgment, my Lord, the preservation, the principle of preservation will not apply to minorities, both aided and unaided. Therefore, my Lord, in the light of 15.5, 15.5 was challenged and it has been upheld. So therefore, in the light of
No
15.5,
quarrel. No quarrel.
yes, now,
Here,
yes,
people from your
Yes. yes,
religious community who are members of the backward class, deserving it for them. Does it abrogate?
I'll tell you, Lordship, why, my Lord.
Or does it abrogate 15.5?
Now, Millard, 15.5, this was actually considered, and the Parliament did not consider it appropriate to include a clause in 15.5 that it will not apply to members, students belong to the minority community. 15(5) does not make any exception. So 15(5) blanket, it is stated in 15(5) that reservation will not apply to both aided and unaided minorities, be it within the minority community or outside the minority community. So once 15(5) categorically says that this will not happen, the socially disadvantaged sections of the community is not required to be given reservation, and which has been upheld by this court, there is no scope to go beyond it and then say, minorities are bound to give reservation to economically weaker sections who belong to minority community. Therefore, that is already taken care of in 15(5). And 30 also, an autonomy is actually granted to the institution to decide which category of students have to be given admission. Then 29(2) comes. That's why if the institution is actually taking it, then they will have to part with certain number of seats to non-minorities. That is the constitutional provision under Article 29(2). Now, as far as unaided minorities are concerned, that question does not arise, because otherwise, we will be going beyond Article 29(2). So, therefore, my submission before your lordship is that this is already taken care of in 15(5), and read with Article 30. Minorities cannot be directed to give reservation to any other sections of the community.
No, we are asking not for any other section.
I am talking about even economically weaker sections of the community that cannot be imposed on them because of the protection given to them under 15(5) read with Article 30.
So you have your 29(2).
Yes.
This part of this judgment is not linked.
I'll tell you, Lordship, difference. Yes, my Lord. I understood your Lordship's question. 29(2) is actually general. 29(2) has nothing to do with economically weaker sections.
No, nothing to do.
So therefore, my Lord, this is actually 29(2). Nobody has got a case that 29(2) is actually violated. Today,
so therefore, if today the institution is a minority institution receiving aid, if the state imposes 12(1)(c), how does it go wrong? How does it affect the minority
because I'll tell you, Lordship, because that is ultra vires 15(5). My Lord, the moment, my Lord, so even if it is economic,
this is also a fundamental right.
Correct.
How do you therefore interpret 15(5), 29, 30 in the light of 21A?
This court was actually balancing 15(5), 21A, and 30.
Is there any discussion on 29(2) in the judgment?
No, there is no discussion. It was not called.
Then
I'll tell you, Lordship, why. Because it was not called, it was not required, because the issue was not parting with certain
if the
seats.
judgment says that the entirety of the act is not applicable even to aided minority institutions,
That
it had to look into 29(2).
I will tell you, Lordship, why.
No decision could have been given without 29(2).
I will tell you, Lordship, why. Because 15(5) specifically exempts all minority institutions from the ambit of reservation. Therefore, my Lord, there was no necessity to go to 29(2). Because 29.
Forget about reservation. We are not concerned so
Yes.
much about reservation as 23. How could 23 be taken out?
I will tell you, Lordship, now by virtue of 29(2), all schools, minority schools, are bound by the constitutional mandate to part with certain number of seats to non-minorities. That is being done throughout the country. Your Lordship,
What about the standard of the teachers? How can you take away that?
now, my Lord, today, I will tell you, Lordship, my Lord, in spite of all these things, there is a rush for admission to minority institutions. What does it show? No, my Lord, they always take the best. No, my Lord, all these things are not required. And today, my Lord, the eligibility test is even otherwise actually enforced through a different route, not through Article 20, Section.
We cannot question the wisdom of the parliament.
Yes.
Right?
Yes.
On the ground level, there may be certain different situations. But when there is a law, and if you say that that law does not apply to us, there has to be cogent reasons given for that. Not in this way, that first part does not tell you the second part.
No, my Lord, that is because
Looking at it from
I will
the
tell you, Lordship.
narrow prism of 12(1)(c), the entirety of the act
I will
is
tell you, Lordship.
thrown out.
Because the central part of Right to Education Act is Section 12. Therefore, and Lord, 21A also provides for free and compulsory education. Therefore, my Lord, the constitutional bench was concentrating on Section 12. And my Lord, as I put it earlier, my Lord, what the constitutional bench was considering is whether the law enacted pursuant to 21A can apply to minorities. Para 54, so constitutional bench has said it can't apply. Therefore, my Lord, there was no need to go further into the other provisions of the Act. But they are specifically referred to Section 12 because Section 12 is the core of 21A.
Mr. Chako,
Yes,
we had shown you various provisions of the
correct.
RTE Act,
Yes,
which were not just confined to 12(1)(c), but were much more.
correct.
Like the norms for recognition of a school,
Yes,
right?
Yes.
The teacher-pupil ratio. How can you say that they will not apply to minority institution or they will not apply to any
Governor,
other-
all those things apply through different route. Today we
Yeah,
are CBSE bylaws.
If we apply, there is no issue about
Yes,
it. And I'm sure minority institutions would be conforming to that anyway.
yes,
We are not concerned. See,
Yeah.
I have studied, my initial education was in a minority institution. I know that they have a very high standard and they admit students from various communities. But the issue over here is then you cannot say that the act will not apply.
I'll tell you.
Our issue is you
that is
address our
answered.
issue.
That is answered in para 65 of society. Because that is what the society said.
Society says with
Inextricably linked.
regard to aided it applies, unaided it does
No,
not apply.
that is one part of it. I'm talking about 60. Kindly see para 65.
Of
Para 65 of society case law. Para 65 said these other provisions of the act are inextricably linked to section 12 and it is not severable.
that may not be an accurate observation.
That will
No, we are asking you, we are now discussing the act,
no.
and if you have some doubts,
Yes,
you may place it.
No, para 65. Yes, Lord. Para 65.
Which
of
volume are you
society.
referring to?
Volume.
Volume
Para society.
Volume?
Volume 3, page 103.
Because we would be considering, no, whether you send it to a three-judge
I'm
bench
only assisting a lot.
or to the justice to decide
Yes.
whether it's keeping a three-judge bench, it can be directly placed before 5 or even before 7. Because to 1981, Anjuman Rahmania two-judge bench sent it to 7 judges, which has been upheld in Aligarh Muslim. That is a 7-judge bench.
Here, there's a difference. I'll tell you, Lordship. Now, difference. I'll tell you, Lordship. In Amdar and this Islamic issue arose with regard to like this 55 with regard to para 68 of TMFI. The only issue was para 68 of TMFI. Now, the 5 was actually decided by a bench of 11 judges. First, it was referred to 5 judges, Islamic. Thereafter, again, it was referred to 7 judges. If that be the case, very well, this honorable could have referred it to 13 judges. Because
Now, so far as reference is concerned,
yes,
reference is concerned, now AMU is the last word.
AMU is the last word.
So AMU has upheld
Yes.
a two-judge bench order of 1981 referring the matter directly to a 7-judge bench.
That is what Dawoodi was actually referred to. And in Dawoodi,
Not Dawoodi. Dawoodi was not there in
Yeah, correct.
1981.
In 1981, it was referred.
Dawoodi Bohra is 2002.
Correct.
1981,
Correct.
a two-judge bench
Yes.
referred Aziz Basha
Yes.
to a 7-judge bench
Yes.
directly.
Yes.
Aziz Basha was a 5-judge bench.
Yes.
This order of Anjuman
Yes.
so and so
Yes.
is having the approval of the 7-judge bench.
No,
Then you can't do it.
No, but there, my lord, there, that was
This is the last word so far as we are concerned.
On that, I am of a different view. I think that last word perhaps may be an error. So I want to address your lordship on
Last,
that.
which one?
That AMU is the last word. I respectfully disagree. I want to actually place before your lordship
You
something.
will have your submission.
Yes,
Why we say so?
yes,
Dawoodi Bohra is by 5.
yes.
Raghuvir Singh by 5.
Yeah.
AMU is by 7. Now, all these decisions have been considered
But
by
the references in all those cases, including Antule Nayak, 2 sent it to 7. Just like in AMU, 2 sent it to 7. But all the sending was done before Dawoodi. After Dawoodi, if there is such a sending, it will be hit by Dawoodi.
No, Dawoodi doesn't say that it is prospective.
No, it doesn't. It
It
doesn't.
doesn't say. Then,
So that
what difference does it make?
That-
Whether it was in 1981 when Dawoodi was not there.
So
So Dawoodi is not.
Alternate 2 was said because you have to overcome a 5-judge bench.
No, but even then, it couldn't have been sent. Using the same principle, it couldn't directly have been.
No, but here your lordship is only
No,
concerned.
can we do this? I refer to 1965 Justice Gajendra Gadkar's judgment.
Yes.
Lala Bhagwan versus Raj.
Yes.
That was pertaining to High Court. Single judge faced with a DB judgment which was binding on him.
Yes.
Could the single judge have said, I'm not bound by the DB? Lordship says, cannot do it.
Correct.
But if you have doubts in your mind, you can jot down the points on which you differ or you doubt the DB judgment. Then you just leave it for the Chief Justice to decide whether it should at all be referred to a larger bench. If the Chief Justice feels that no, that's the end of the matter. You are bound by the DB. The same thing here. Can we leave it to the Chief Justice to decide? Even to a certain extent, Dawoodi permits that.
Yeah.
You don't say that it has to be referred to a larger bench. You say that for XYZ reason, we are not persuaded to agree with the 5-judge bench. Please consider whether it requires a reference to it. It's the Chief Justice who is to take a call on the administrative side. Otherwise, what happens? Instead of Pramati being a 5, if it had been 9. So 3, 5, 7, 9, 10, 11. What is this?
Well, I think there's a larger question. There are 2-3 questions which arise out of this. Allow me to address you after this.
No, my submission for your lordship is, if your lordship is only worried about what is actually stated, it is actually para 55. It's an interpretation of para 55. If it is an interpretation of para 55, my lord, that can be decided by your lordship. It can be decided by 3 judges. There is no necessity to refer it at all. That is what is actually done in Pinamdar.
I don't want to commit any impropriety.
No, my lord, what I submit is, no, my lord, unlike my lord Aziz Pasha, my lord, entirety of Aziz Pasha was actually questioned. Here, nobody is actually questioning Pramati in its entirety. What is actually what doubt is only with respect to one particular paragraph, like what happened in TMFI. Doubt is only with respect to para 68. Therefore, my lord, it is as the learned ATS submitted before your lordship, my lord, it is always open to your lordship or a 3-judge bench to interpret it, my lord, to clarify it, my lord. For that, my lord, no reference is actually required. If at all it is required. My submission is that it is not required because 21A is actually very clear, my lord. It can, an enactment pursuant to 21A can only be for the purpose of implementing free and compulsory education.
Mr. Attorney, you relied on AMU, on minority part.
Yes.
In which volume is it?
It was given.
I think I
It
gave
is separate volume.
I lied there.
It's an independent judgment.
I, in fact, have a note with the extracts of the paragraphs of all 3 judgments in AMU. The lordship folder. On this point, only
I
on
just wanted, because,
yes.
are you having Justice Gajendra Gadkar's judgment? 65 AIR.
Called for it, I'm not sure.
We did not mark your compilation.
No, it is not. I did not.
Not
What I will do is
Compilations are till 8, volume 8. Volume 9. Where is volume? Which one? Volume 9 is by Mr. Gopal.
This is 9.
Yes.
So this will be then probably
This is different.
AMV is a very big, probably that's where the courtmaster has put that could be AMV.
If your first compilation, how does it look like? You have a copy here?
Yeah, I think there's a one. It was given a handover.
A judgment.
Courtmaster just below that, I think that. A legal below.
Yeah.
You know what?
This is the
Yes.
Para 21 of my Lord Justice Datta's judgment.
There are 21.
Yes.
Yes, Justice Gajendra Gadkar's judgment, I have put it. It's page 152.
65, 3 SCR, 218. That judgment.
Just place it.
Give me para 21. Para 21.
Para 21, yes. Renew para 21,
Yes, yes, yes.
quoted from para 18 of Justice Rajendra Gatkar's judgment.
The discussion on why the order in Anjuman is completely flawed and thus should not have any bearing on
No, don't read that. Come to Justice Rajendra Gatkar's.
Yes,
That's the
replicating
minority.
the approach of the single judge of the relevant High Court, who had taken upon himself the task of deciding whether earlier decisions of division benches of the same High Court ought to be reconsidered and revised, based on his perception that such decisions stood impliedly overruled by a decision of this court. Honorable P.P. Gajendra Katkar, CJS Lordship then was, speaking for a bench of three, observing, it is hardly necessary to emphasize that considerations of judicial propriety and decorum require that a learned single judge hearing a matter is inclined to take the view that the earlier decisions of the High Court, whether of a division bench or of a single judge, needed to be reconsidered. He should not embark upon that inquiry sitting as a single judge, but should refer the matter to a division bench or, in a proper case, place the relevant papers before the Chief Justice to enable him to constitute a larger bench to examine the question. That is the proper and traditional way to deal with such matters, and it is founded on healthy principles of judicial decorum and propriety. It is to be regretted that the learned single judge departed from this traditional way in the present case and chose to examine the question himself.
This is exactly what we don't want to do.
Exactly. And I disagree with Mr. Chacko on this. I don't want to, and the learned attorney on this. I don't want to invite your lordships to do that. Please don't. I think it was unhealthy what happened in 5 judges and 7 judges with a 11 judge judgment. That should never have happened. It happened. But hopefully we will not keep repeating this. The reason why we have judgments and precedents and larger bench constitutions in this court is that we respect that. And there's a binding nature that it has. So it is not for smaller benches, in our view, to be invited to interpret this contrary to what.
So I maybe some very interesting exchange of views here. So how do I read a judgment? I bring my own understanding of it in the context of certain issues presented to the court. The court is then says, well, it's binding on me. I can't do any exercise of understanding the judgment. In every case when a judgment is presented to the court is essentially engaging in understanding the judgment. So if we understand the judgment, the court is now called upon. Is it a ratio? Is there no ratio? Can the court say, no, I can't even do that exercise? To say that, therefore, there's a larger bench. I read it as a text, holy text as it is, but I will understand as it is and will not say anything more. I think it doesn't happen like that.
But
Every day
Mr.
it is-
says he should not, single judge
That's right.
should not embark upon that inquiry sitting as a
That's it.
single
I
judge.
haven't asked you a lot to say, getting into an inquiry at all. And I also thought, let me place, since 29 has been referred to, I think it's also important to just make one point there. 29 is a non-discrimination article. It's not. It probably doesn't have any direct connection to Article 30, if I understand it correctly. If you read 29.1, 29.1 is a fundamental right of vast importance. Any section reciting so and so language, script, or culture has the right to conserve the same. The state will not enter into this territory at all. And then 29.2, therefore, is a logical conclusion of it. I will have a right to enter into any arbitrary any institution maintained by the state. The state shall not discriminate. The state, by giving a fund, will say, I will admit so-and-so class, so-and-so religion, but not so-and-so religion. So it's a non-discriminatory article. It has nothing to do with any concern about whether an institution will have an obligation to advance a national concern or national cause. 29.2 cannot be expanded in that way at all. The state shall not discriminate.
So, but 21A is an obligation of the state.
That's true. Therefore, the
It's
state shall not discriminate.
correct. But the only question is that within their own community, if the state were to say that you admit people from EWS category, that would not be violative of 30.
That's right. But I want to say the connection, the so-called nexus between 29 and 30, perhaps we'll break when talking about Article 21A. I don't think that connection can be brought in. 29 will operate entirely different there.
Anyway,
Before I conclude, there's the World Education Forum, which is where UNESCO is part of the World Education Forum. UNESCO, World Bank, many international organizations. I'll just place only one page of the document. It's called the Dakar Framework for Action in 2000. Not just, it's a very lengthy document. Paragraph 7. I think this third page, first page. Paragraph 7. And paragraph 6 also. Education is a fundamental human right, key to sustainable development and peace and stability within and among countries, and thus an indispensable means for effective participation in the societies and economies of the 21st century, which are affected so and so. Achieving the EFA goals should be postponed no longer. Basic learning needs of all can and must be met as a matter of urgency. We hereby collectively commit ourselves to the attainment of the following goals: expanding and improving comprehensive early childhood care and education, especially for the most vulnerable and disadvantaged children. And ensuring by 2015 all children, particularly girls, difficult circumstances, and those belonging to ethnic minorities have access to complete free and compulsory private education. Then a learning needs of young people and adults are met through equitable access. Then C5 about gender disparities and gender equality. Then 6, improving all aspects of the quality of education and ensuring excellence of all, so that recognize that measurable learning outcomes are achieved by all, especially in literacy, numeracy, and essential life skills. So to achieve this goal, we, the government, organizations, so and so, pledge ourselves to do all this. Mobilize strong national and international political commitment. 1. 2. Promote EFA policy in a sustainable and well-integrated sector framework, clearly linked to poverty elimination and development strategies. Then 3. Ensure the engagement and participation of civil society, which means all the educational institutions, in the formulation, implementation, and monitoring of strategies for educational development. So it goes on, a very interesting set of principles. And see, paragraph 9, enhance the status, morale, and professionalism of teachers. Open the minority. Yes. Just before to conclude, paragraph 65 of the unaided minority judgment, that is volume 3, page 103, which is referred to. How do you really say
Page, sorry?
Page 103, paragraph 65.
That's the minority bill.
That's right. I want to see that, please see that once again. The big judgment, as I said earlier, does not.
Paragraph
65, the majority judgment. The Your Lordship see in the judgment does not take, either say, pen and paper to say which provision violates which provision of the Constitution. The focus was mostly on 12(1)(g), even though the court looks at the various provisions of the Constitution, of the Act. So, paragraph 65 it says, however, the said 2009 Act, the Lord is anyone got it?
Just a
Don't.
You're referring to volume
3.
3.
Volume 3, page 103.
Okay.
Yes.
However,
103.
3, yes.
65.
No.
101.
101.
101, sir.
Yes.
101 at page 60.
Yeah, PDF page 1.
Yes.
I'm so sorry. Very.
Yes.
However, the said 2008 Act, and in particular, Section 12(1)(c) and 18(3) infringes the fundamental guarantee to unaided minority schools under Article 30. Also, and consequently applying the RMD the principle of severability, the said 2000 Act shall not apply to school, meaning that by the provision referred to above will not apply.
No, 2009 Act and in particular.
That's right. That's what they refer to those.
Entire Act.
I think I would also read this like that because
No,
in this
otherwise it could have read like this.
Yeah.
However, sections 12(1)(c) and 18(3) infringe fundamental freedom under 30. Therefore, why would they say said Act in particular? It encompasses that thing. But the only thing that can salvage from this paragraph is
so what will be
it
said?
has left aided minority institutions aside. It only applies to unaided.
In the context of application to unaided minority schools, what is being looked at is 12(1)(c) and 18(3).
18.
Then where is the need for the court to apply the severability principle?
No, just see the sentence is repeated in para 62 last line.
That's true.
Again, same line. It's not inadvertent. This has come.
That's 12(1)(c). I'm not saying inadvertent.
See, including. See, what my brother is pointing out is
Yes.
that it says the entire act, including 12(1)(c).
But having said that,
Yes.
having said that in 65 they talk about 12(1)(c) and 18. Now I ask myself a question: if the entire act is in infringement of the D, then where is the question of applying the severability principle?
No, severability principle. Otherwise, the whole act, the
Having examined it, unless I'm sorry. What did it say?
What they meant was that we have saved the act. Otherwise, the whole act could have gone. RTE Act could have gone. So we say that to the extent it applies to minority, it goes. The rest remains.
May have it put it. I understand. I don't think whether it's applicable to Class A institutions, the court can clearly say there is no need for severability doctrine at all. Be very clear. The severability doctrine can apply only in the case of an applicability. This will apply and this will not apply.
Yes.
But you're talking about two independent classes of educational institutions,
Yes.
minority versus non-minorities. There's no need for severability.
No,
They will not apply, they will apply.
that is because 2N defines all schools.
That is true.
1, 2, 3, 4. So that includes minority.
Absolutely right.
Ah.
That's what they say. Take out those provisions. Those provisions will not apply to minorities. That's about all.
Correct.
To say that they act, I can't read.
So
I
how
can't-
do they say that the act does not apply to minorities? They can.
I have no disagreement on that. I have no disagreement on that question.
That's the way they found out. That's one of the multiple ways. Yeah.
Therefore, this is somewhere there is I would know the lack of precision. Lack of precision.
How would you have done it? Suppose you felt
Yes.
that the act, to the extent it applies to minority institutions, falls foul of Article 30.
Right.
How do you have couched the relief?
No. Then
There is no other way to do it other than this.
I would, of course, it's a very different way of rewrite looking at the judgment. The court would simply say, as far as the act is concerned, these provisions, all of them will apply or will not apply to unaided minority schools. Some of them will apply to minority schools, they will not apply.
Ah.
That's how it will happen.
But that they have not said because they felt that the act did not apply to the minority institution.
I understand.
That's a conclusion that he had.
Therefore, to say that this judgment
Yes.
occupies the field of entire law in relation, on the other aspects of it we're talking about.
Yes.
That I don't think that will draw sense from this observation.
In fact, the previous para they've explained, they've given the 4 categories to which it would apply, which is why the one category left out is what is explained in 65.
That is
Anyway, that will be a good question.
Yes.
Neither there.
But I just wanted to address you on this limited issue of the reference. We made a small note. Yes, sorry, sir.
No, as far as the teacher's issue is concerned, I think it's also important for the court to say that the NCT Act rightly occupies the field relating to quality of education. And Section 23 notices that, and therefore that can't be a case stop. And those regulations issued from time to time have been issued in public interest, the interest of excellence of education. But since we have this problem, like in Article 142, notwithstanding many opportunities they might have had, with reference to this David weapon, either. So what this court has said in David, kindly make a note of that.
We have Xavier with us. Tell us the page number.
Volume 2, page 412.
Oh,
JB it is. Volume 1.
JB.
Volume 2, page 414.
Volume 1,
Volume 2, page 414.
which page should we turn to? 414.
Yes, Your Lordship. 18.
No, that is volume 1.
Volume 2.
Volume 1. Volume 1.
yes. Volume 2 starts from 452.
Volume 1. Your Lordship.
Oh, madam, you've got the wrong page number. Xavier starts from page.
Xavier's Jaivir.
JB.
JB.
Okay, okay, JB.
Jaivir. That's
That is
volume
in Volume 1.
414.
There is an apparent conflict in Bombay, no? The two division benches have taken two different views. This is Supreme Court. Yes, which paragraph?
This is not the conflict. This is the DLN. The exception I told you, Lordship, which is clarified a year later by the Supreme Court.
18 months.
18 month versus 24 months.
We have not seen this judgment before. No?
Yeah.
No, I had referred it to orally, but I thought.
There is no marking
Yes.
here.
Attorney, you are referring to this judgment?
Paragraph 70 to 20.
Paragraph 70.
$429. No.
70 starts.
Yes.
It could thus be seen from subsection 1 of section 23. The RTE Act, the person to be eligible for appointment as a teacher must possess the minimum qualification laid down by an academic authority or with the central government. Permit the central government to lack of minimum qualifications requires appointment for such period not exceeding 5 years. This can be done where a state does not have adequate institutions offering post training and institutions or teachers pursuing minimum qualification laid on so and so are not available in sufficient numbers. However, the first provision of section 2 that provides that the teacher who the government that does not possess minimum qualification laid on in subsection 1 shall acquire such minimum qualification within a period of 5 years. So 2017 Amendment Act second proviso was added, which is retroactive effect from 2015. It provided every teacher appointed position so and so does not possess the minimum qualification shall acquire minimum qualification in a period of 4 years from the date of commencement of the 2017 Amendment Act. It can be further seen that next to the powers conferred and so on so central government authorized NCT as an academic authority to lay down the minimum qualification for the person to be eligible for a teacher. Accordingly, NCT 2, they're talking about those notifications. Then 22, the communication dated 2017 is noticed. It's a matter of concern that untrained elementary teachers are in schools. And then paragraph 23. It is thus clear that all such teachers working in either government-aided, unaided private schools were required to acquire the minimum qualifications by 31st March 2019, or they would face dismissal from service. It appears that it was the same central government to provide a window for all such teachers. The perusal of said communique related all various directions which show that the lakhs of teachers were untrained with the requisite qualifications prior to April 2019. The communication so and so date so and so, etc. would further clarify the position. Paragraph 25. It's thus clear, paragraph 25. The said recognition order was issued to the directive of the MHRD for implementing Act duly fulfilled. It appears that since the time gap between the direction issued by MHRD and 31st March was only 18 months, the period of course was reduced from 2 years to 18 months. This position will be clarified from said recognition orders and so also. Any provision related to the duration of the programs was reduced to 18 months instead of 2 years, and the requirement of 6 months internship to be subsumed within a duration of 18 months. Then we have 8. Then you look kindly see paragraph 28. second thing, it further clarified that the NCT recognition order was only for those untrained in-service teachers in government-aided, unaided private schools who were appointed on before 10th August 2017. Clarifies fresh appointment, also notifications also need to be strictly adhered to. Further note, whereas notification specifically refers to powers conferred in subsection 23, NCT recognition order date refers to correctly issued by MSRD under section 20 of the RTE Act. It's thus clear that the entire scheme was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired the requisite qualification prior to so they could not have continued to remain in service and would have faced dismissal from service. As such, we find High Court urging the holding that the 18-month diploma course conducted the NE so is equal to 2-year diploma for which notification to the NCP. So what I mean to say is, even the court will so strictly construe on an equivalence that will not be sufficient for the purpose of excellence and to weed out in service untrained teachers. That will be noted. Therefore, if the court now find that regardless of all this and notwithstanding all this exercise, if there are teachers who need to be probably given on final opportunity, the court may streamline it and ask NCT to provide a certain guideline in this regard, and to ask all the state governments to cooperate and see that within a period of, let's say, a period of maximum 1 year, all these things can be completed. So that nobody faces a hardship of being thrown out without being given an opportunity, a fair opportunity. And also, schools should not go without teachers. That's also important. Grateful, Your Lordship.
Just two quick responses on first principles first. Article 29 in
You said you would be starting with the reference part.
not I could, Your Lordship.
So within 5 minutes and then 2 o'clock you go on to the,
I'll finish the whole thing, I think.
Mr. Nataraj is also there.
Yes.
Just let us hear on the reference part, because we'll then
Let's not
segregate.
roll it.
We'll segregate.
Yes. I've handed up a note, if Your Lordship can take a look at that. I believe there is some issues that the court seems to be facing on how references have to be done. And try as I might, I couldn't find resolution, because I'm sure the courts are facing the same situation when they have to refer questions to larger benches when they're binding. In what kind of situations, what can the court do? How should the procedure be followed? The first question of the court is whether a smaller quorum can indicate the numerical strength. I want to underline that, because Your Lordships are right. When you say that once you have indicated that, that's binding on the Chief Justice as well. Just because it goes to the administrative side doesn't mean it ceases to be a judicial order of the court, which is why, of a larger bench to be constitutable, referring the case to the Chief Justice has not been decided in any of the cases. While the question arose in Aligarh, this aspect is not discussed by the majority of 4 judges in the finding at para 39. While doubts have been raised about such a course by Justice Kant, paras 94 to 98, and Justice Datta, paras 22, 23, and 28. We have annexed those. So this is only 1 page. The rest of it is the extracts from the judgment to show Your Lordship. Note, the question of such a direction being binding on the Chief Justice may not be moot in view of Article 144. I believe it is a judicial authority under 144. So acting
All courts and all civil authorities and judicial authorities would be bound.
So the question is whether a bench of lesser quorum, while acting in terms of the first exception laid down in para 12.3 of Dawoodi, can indicate the numerical strength of a larger bench to be constituted while referring the case to the Chief Justice. This doesn't appear to have been answered anywhere in a majority. 2. There appears to be ambiguity on the nature of exceptions carved out for reference by lesser quorum to a larger bench, as the exceptions contained in para 12.3 of Dawoodi have to be reconciled with that in para 7 of Parija to the extent that Article 145.3 is to be interpreted. Both these judgments are of 5 judges, but do not deal with the situation where an existing binding judgment has already been rendered. If I can just point out, Parija was delivered on 4th December 2001. So dealing with the case of a 2-judge bench, reference directly to 5. Now, in 5, Parija draws 1 exception, which is the Article 145.3 exception. Dawoodi, dealing with similar issues, when it's a reference from 2 to 7, gives directions and then gives exceptions, but it doesn't take into consideration the Parija exception. So where do we stand today when we seek guidance on how a reference is to be made? We have two constitutional bench judgments, one in 2001, the other in 2004, both providing exceptions, but not reconciled on two aspects. One, Article 145.3, which is a constitutional provision which says that when there is a question that involves an interpretation of the Constitution, and I believe this present case does. It definitely does involve an interpretation of 29 to 21A 30. When that arises, clearly the court has to exercise, whether it's a bench of 2 or 3 or 5, the court has to exercise that power. How does it exercise that power? And if your lordships feel it's a question of constitutional importance, if two Supreme Court judges feel it's a question of constitutional importance, it's a question of constitutional importance. Then minimum it goes to is a bench of 5. So that has to have been considered. Whether then can you decide 5 directly? And it says minimum. The word minimum in the Constitution is very important.
Settled law that we can't do that.
I believe that
We can't identify the numerical strength of the bench to which it is to be referred.
so because there is no verdict on that
No,
today.
there is.
On what
There is. I'm
Yes.
reading paragraph 26 from my judgment in AMC.
Yes.
Campaign for judicial accountability.
For me, that's the problem because that's a minor decision.
No. Campaign for judicial accountability is a 5 judge.
Oh, sorry. I thought.
I'm not relying on whatever I have said. I will only be referring to the judgments.
Yes.
See para 26.
Yes.
What campaign has said.
Yes.
There cannot be any kind of command or order directing the CJI to constitute a particular bench.
I'm not doubting that.
So there will be. Or it does not require a reference.
Yes. But I'm not
Coming
sure
back.
if campaign of judicial accountability has considered the 145 point. That's
No.
all. I'm okay with that. I'm with that narrative.